The marble courtroom of the Franklin County Superior Court smelled faintly of old wood and tension. Every creak of the benches seemed amplified in the hush. Attorney Miles Carter, 34, adjusted his cufflinks and rose slowly from the defense table. He carried the quiet confidence of a man who had built his career on careful preparation. But before he could speak a single word, Judge Harold Whitmore's gavel cracked like a gunshot. "Counselor," the judge barked, his baritone slicing through the room, "spare us the theatrics. Stick to the facts." Gasps rippled through the gallery. Miles hadn't even begun. His client, a young community organizer accused of inciting a protest that turned chaotic, stiffened beside him. Miles met the judge's icy glare. He'd been interrupted before, too many times, in too many courtrooms. But today felt different. This was the hearing that could define not just his client's freedom, but the fragile precedent protecting the right to peaceful assembly. He inhaled, ready to push forward. "Your Honor, with respect—" "Counselor," Whitmore cut him off again. "You will answer only the question asked. Nothing more." The stenographer hesitated, unsure how to capture the silence that followed. The air grew heavy, like a storm cloud waiting to break. Then, a sharp electronic trill sliced through the tension. The judge's private line, an old black rotary phone mounted beside the bench, rang loudly. Everyone froze. That phone was reserved for one source only, the chambers of the United States Supreme Court. Whitmore's eyes flickered just once, betraying the faintest crack in his granite demeanor. "Court will recess," he muttered, voice suddenly subdued. He lifted the receiver. "Yes, Chief Justice?" Every spectator leaned forward. The bailiff's hand hovered near his holster, as though the very hierarchy of justice might collapse if anyone so much as whispered. The judge disappeared into his chambers. Minutes stretched like hours. Miles remained standing, heart pounding but face unreadable. He thought of his grandmother who had marched in Selma, and of the nights he'd studied case law until dawn, because she told him, "The law can be a weapon, if you learn how to wield it." When Whitmore finally returned, his face was pale, almost translucent under the fluorescent lights. He cleared his throat, struggling for composure. "This court," he said, each word deliberate, "has been advised by the highest authority to allow full and uninterrupted argument from the defense." A murmur swept the room. Reporters scrambled for their phones. Miles stepped forward, the weight of generations at his back. His voice, calm and resonant, filled the chamber. He laid out precedent after precedent, Brown v. Board, NAACP v. Claiborne Hardware, stitching a narrative so airtight the prosecution seemed to shrink with every sentence. This wasn't just a defense, it was a declaration that justice is not a favor dispensed by power, but a right demanded by those willing to stand, even when silenced. Hours later, the judge returned with the ruling. Case dismissed. The gallery erupted, first in stunned silence, then in applause that the bailiff didn't dare quiet. Outside, the courthouse steps swarmed with cameras. A reporter asked Miles how it felt to win because the Supreme Court intervened. Miles shook his head. "We didn't win because the Supreme Court called. We won because the Constitution already had the answer. Someone just needed to listen." That evening, as the courthouse lights dimmed, Miles walked alone beneath the cold stars. He knew tomorrow another courtroom might try to interrupt him, another gavel might strike early. But he also knew something fundamental had shifted. Because sometimes the highest court doesn't just uphold the law, it reminds every judge, every lawyer, and every citizen that silencing the truth is the greatest injustice of all.